to or skip.
Rabbit.
And then do I stop it anyway? Or
Yes,
are they gonna-
they will at the end,
Oh, here or at the end
at
of
the very end.
The whole thing,
So I'm gonna do just this.
about whether they take our
And then the
recommendations.
recommendations. And then this, not that. And where's the recommendation?
We will do this.
Very end, you should have the thing.
There is just resolution, CMH.
Once I grow up, whether or not I'm married, those things.
Yes, but there was always.
You give this much.
Just a resolution.
At the end, you should have the final thing that the committee recommended, you know, the thing where they vote, right? That last sentence is.
Yes, and then the chief applies first.
Resolution.
And if anyone has questions.
I'm gonna give them my phone number. 979.
And there's a couple people for, so you'll see. I think the public. Well, you're right before me, but we're.
Thank you, yes.
Absolutely.
Yes, it is.
Keep giving you more work, don't they?
Find something else.
We're gonna see how you do your thing and then we'll do it.
I know, right?
You're first, I thought.
I know, I'm like, what?
You have a
Should
couple.
we read this?
I always forget how we.
Oh, wow, that's good.
I loved him.
Every time we raise one.
That's wonderful. That's great.
Hasn't gone anywhere, huh? Summer hasn't gone anywhere.
My wife is up in North
They
Carolina.
did the same thing in my
I bet it's
country.
Just nonstop raining. She's all right.
Slip up.
Yeah, she's with her.
The hurricane and
Yeah.
stuff,
Yeah, well,
right?
her 90-year-old, her sister who stays with her mother there, went off to Europe somewhere, so she went up there, and of course, that's what.
I know.
Okay, but they're,
They're good.
she texts me, so.
Then I'm not cheating on text.
They're not so good.
It's just been nonstop. In Florida, it's been nonstop. I was there about a couple weeks ago.
Oh, when it was raining?
Yeah, they said, oh, for the last 2 weeks.
Yeah, I used to live in Tallahassee.
Yeah, well, and they usually don't get a
They
hurricane thing, and they,
No, we always called it Southern Georgia.
yeah.
Whatever.
She did mock trial last year, and Senator Zaffarini also runs an excellent mock trial program. And
You went through the whole, we started.
pages.
Yeah, we filled out the questionnaire, so
Yeah.
I think,
You enjoy it though, it
Louisville.
really does.
Yeah, I am.
And we still have a lot of things that we wanna do and to do.
Michael's gonna learn about municipal courts now too. We are kind of
You're doing
different.
it, Judge.
Yeah, oh yeah, I've been.
You know, seeing
I did
everybody,
at
I'm
first,
like,
but I didn't see. See others.
We'll get underway here.
My sister was
Good morning.
Morning.
We'll call her up.
Justice Heck.
Here.
Presiding Judge Keller.
Here.
Miss Bash. Mr. Bryant.
Here.
Justice Coy.
Here on the phone.
Miss Clayton.
present.
Senator Creighton. Mr. Gimbel. Judge Gravel. Judge Laird. Representative Leach. Judge Maderi.
Here.
Justice Miskell.
Here.
Judge Nash. Judge Person. Miss Rax. Judge Sawyer.
Here.
Representative Smith.
On the phone here.
Judge Spillane.
Here.
Justice Wise.
Here by phone.
And Senator Zaffarini.
The meeting is being webcast live as always, and also recorded and will be archived and available later on. Today we'll discuss and adopt the committee reports and recommendations that we've been working very hard on. This is the core of the council's work. in presenting recommendations and resolutions to the legislature for consideration in the coming session. I appreciate the hard work that the members have put in. I started early reviewing the resolutions, and it's a good thing I did. There was a lot of them. But I appreciate all that has been done. The judiciary has come through a hard patch, I tell people, with COVID, but we're digging out of that and kind of on the road forward, I think. And then we have the exciting development of new business courts and the new Court of Appeals. So the 15th Court of Appeals, we got our first case from them earlier this week, and we didn't reverse them, so they're 1-0, 1 for 1. But we look excited about the work they're going to be doing, setting up their dockets, getting courtrooms, court space, chambers, court reporters, clerks, all the stuff that it takes to have a court. I will say, very grateful to the Texas A&M Law School and Dean Alday for helping locate the judges, but also having the swearing in for the business court judges last week. The governor was there. So the A&M Law School has been very helpful in trying to get the business courts on their feet. So we're grateful to them. And the 1st and 14th Court of Appeals are helping other places around the state working on. So we're grateful for that. I have to tell you, you know, that public trust and confidence in all of our institutions has sunk in the last several years, probably due to national politics. The judiciary has not escaped, and the numbers in 2022 were the lowest in history. And for the first time, more people thought that they would not be treated fairly by the courts than thought they would be. It was close. 48 thought not, and 46 thought they would be, but it's still, that's down from historic numbers in the 60s, reacting favorably to the justice system. So part of that is controversial judicial decisions. We can't do anything about that. The law is the law, and we've got to call it the way we see it. But we can make the system run better, and that's really something that the council has a key role in. So people can come away from the system as they have been, for example, with remote hearings, and it takes less time and expense to get to a hearing and participate in it. I know family courts have found that participation is way up because people don't have to take off work and just push a button and zoom in, and that's a very good thing, but we need to keep working on it. We've got a lot of ideas here in these resolutions and reports today that will move us in that direction. So we'll get to it here. You've seen the minutes from the last meeting, April 27. Any objections or corrections? Not, they'll stand approved. Then we'll move to the reports, and we'll begin with the Indigent Defense Commission.
Thank you, Chief Justice Heck, Presiding Judge Keller, members. I'm Scott Ehlers, the Executive Director of the Texas Indigent Defense Commission. We've been very busy over this past quarter. Our board met 4 times since April. On April 5th, when we when the board approved recommendations from our salary work group, which analyzed salaries at public defense offices around the state. On June 24th, they met to go over our legislative appropriations request. June 28th, they approved the TIDC's LAR and numerous grants, and they also selected Judge Maderi to become TIDC's new chair. So welcome, Judge Maderi. I hope you haven't been scared off yet. And she's taking over from Judge Keller, who has been our chair since the very beginnings back in 2002. So thank you, Judge Keller, for the many, many hours you've put in as our chair. On August 29th, the board met. We awarded Judge Roy Ferguson from Far West Texas the Robert Dawson Indigent Defense Distinguished Service Award for all the great work he's done out in Far West Texas. The board approved some legislative recommendations and received the results of the Family Representation 2023 data report. We have 4 new members on the board. Jim Bethke, former TIDC director, and now the executive director of the Bexar County Managed Assigned Counsel Program is on our board. Justice of the Peace J.R. Woolley of Waller County is now on our board. The governor earlier this month appointed Judge Bill Gravel and Justice Emily Miskell. Welcome to both of them to TIDC's board. Those are slots from the Judicial Council who serve on TIDC's board. Judge Gravel is replacing retired Judge Vivian Torres, and Justice Miskell is replacing Sherry Raddick from the First Court of Appeals. And thanks to them for their many, many years of work on the commission. We have 2 new staff, Senior Policy Analyst Kendra Brown and Fiscal Analyst Will Jones. We've been doing policy monitoring, physical monitoring, trainings, recruiting around the state as we do all the time. One of the things I did want to highlight is our outreach to law schools. Because of our severe attorney shortages around the state, we have been reaching out to law schools, doing public defense days to try to get law school students interested in the work and let them know about all the career opportunities in public defense. On the legislative front, this past summer, we had a number of legislative work group meetings to gather stakeholders together to provide recommendations to our board on legislation that they approved in August. TIDC submitted its legislative appropriations request in August, and I presented to the joint budget hearing earlier this month. Our LAR includes 4 exceptional items, which you're going to have an opportunity to vote on here in a moment on through Resolution 1. And so item number 1 of our exceptional items is a request for $12 million in general revenue to address a revenue shortfall we have in the Fair Defense account, which is a general revenue dedicated account. Item number 2 is $8.9 million to address attorney shortages through a pipeline program that includes internships, fellowships, and loan repayment programs for attorneys working in public defense and high needs areas. Item 3 is $47.5 million to operate TIDC's Family Protection Representation Program, which was established thanks to Senator Zaffarini's SB 2120 passing last session, and that would fund grants to counties and 5 FTEs. And item 4 is for $35 million to increase TIDC's capacity to fund new and expanded public defense offices, especially in rural counties that are facing attorney shortages. That's it for my report. If y'all have any questions, happy to answer them.
Any questions? Thanks very much, Scott.
All right, thank you, Justice.
We need a,
Adopt the resolution.
yeah, so, is there a motion to adopt the PIDC resolution?
Second.
Any discussion? All in favor?
Aye.
Opposed? It carries. We'll turn to the Civil Justice Committee, resolution and recommendations. I believe Justice Miskell has the.
All right, you're going to be hearing a lot from me today because not only am I doing civil justice, but I am also substituting on data committees. So, Megan, do you think I should go through each resolution and vote as they come up, or should I walk through everything and then come back and vote on the resolutions?
I would go through everything and then vote on the resolutions.
Okay, all right, let's do that. All right, so our charges are on the inside cover of the Civil Justice Committee report, so I'm not gonna re-go through all of that. But we met, we've had 3 meetings. We met in April and June and covered about half of our charges in each meeting, and then we met again in September to discuss the recommendations that we're bringing to you today. So looking at the first group of our recommendations, court efficiency, we basically have 2 categories. First of all, an ongoing theme is to sort of streamline and simplify our Texas court jurisdictions. As you know, if you ever look at the OCA annual statistical report, one of the infographics is a very confusing flow chart of how our court cases go in our court system in Texas. So 2 of our recommendations relate to the first 3 recommendations relate to amounts in controversy. So this started with raising the amount in controversy for statutory county courts from $250,000 to $325,000. This is just consistent with inflation and basically keeping that dollar amount, essentially the same as where it was when it was set. But then when we were talking about raising the maximum amount for county courts, we also turned to, we probably need to deal with the minimum amount because we have a lot of overlapping jurisdiction. The Constitution has a dollar amount in it, which essentially specifies that the minimum amount in controversy for district courts is $200, which causes a lot of unnecessary duplication at this time, especially when, for example, the filing fee is over $400, and we have now amounts in controversy for justice courts up to $20,000. So it would really streamline things to allow the legislature to manage what is the appropriate amount in controversy for each level of court, rather than specifying a dollar amount in the Constitution, which is hard to change. So that is our other 2 recommendations. Number 1, that we probably need a constitutional amendment to remove that $200 amount from the Constitution and leave that decision to the legislature. And then secondly, with that, if that passed, then we would be able to raise the minimum amount in controversy for civil cases that are originally filed in district courts. So all of those 3 recommendations sort of relate to streamlining amounts in controversy for all this overlapping jurisdiction that we have in our court system. Any questions on that before I move to the second category? Okay. The second category has to do with local administrative judges. So this is sort of a behind the scenes function. Our Texas courts are very decentralized. Basically, judges don't really have bosses, but there's still a lot of administrative coordination that needs to be done. And so the government code creates this role called local administrative district judge, local administrative county court judge. And their job functionally is to deal with court security, deal with the sheriff, deal with the commissioners, deal with, whatever, all the administrative business that has to go on in a county. And so how it works is the judges, the district judges or the county court judges, pick their administrative judge who serves a term. The current government code says the term is a maximum of 2 years, but there's such a learning curve with that role, and it's so dependent on the relationships that you build with other county departments, that one of the recommendations we have before you is to change that from a maximum term of 2 years to a minimum term of 2 years. Each county sort of does this differently. So in Collin County, we have a norm that you serve your 2 years and you don't serve back to back. But I believe in other counties, for example, Harris County, I think they serve, many years in that role because of the complexity. But this would still let each county decide how they want to do it. It would just give some consistency with having a judge be at least 2 years in that role. Concurrent with that, we are recommending that a manual be created. So when I first became our LADJ for Collin County, I was like, is there a list of my tasks? Like some of them are in the government code, but also others of them are spread out here and there. And so this is something that Megan and I had talked about a long time ago, and I think it's gonna be very useful because, for example, we just talked about TIDC. The local administrative judge is the person who submits the plan for the county and all this other data to TIDC, both for criminal and now for CPS cases. Well, if you have a new judge coming in who doesn't happen to hear criminal or CPS cases, that's gonna be a big new responsibility for them that they might not know exists, and there's consequences for not doing it right. So having a manual would be great. And then the next recommendation is, there are so many tasks. I probably had the worst of it because I was LADJ during COVID and having to coordinate, court systems and our sheriff and the jail and all of that. But it was like a part-time job on top of my job. And judges who volunteer to take on these responsibilities get a supplement of $5,000 a year, which I was earning well under minimum wage for those tasks. So that's fine. I mean, we need people to coordinate them. But one of our recommendations is, given the increasing tasks on that role, perhaps that supplement amount should be increased to match the increase in responsibilities. So those recommendations all relate to local administrative judges. Any questions or discussion on that topic?
What is the amount that you all are going up for the LADJ?
We did not specify an amount, and I don't remember what the resolution says. I mean,
Yeah, I have to tell you, it's interesting enough in some of my, it is, I mean, you're nice to call it a part-time job because it is a lot of work. And a lot of individuals in my region, the 5th region, I mean, some of them love to be LADJ and others fight not to be LADJ. So, I mean, I think your recommendation is a good one.
yeah, we've heard that some people like it. My experience in my county has been that we voluntold our next LAJ who they were be, and I joke that we had 13 judges and the vote when I became LADJ was 12-1 with me voting against. So.
Yeah, that's how it is in our jurisdictions.
Our next bit of business has to do with the Children's Commission. So the Children's Commission brought their recommendations to us. We did talk about them in our Civil Justice Committee meeting, and all of them seemed sensible. One follow-up question I did want to ask, Senator Zaffarini correctly pointed out that they needed to run those by DFPS before we talked at our meeting, which they did so. And I believe Dylan's email said they were withdrawing number 8, and is that in the resolution though that we have in front of us? I believe that's resolution 4. Did they mean to withdraw number 8 on resolution 4?
It's still, number 8 is still on there, so we can make that
Just double check.
change. The requirement, required placement of a child in the least restrictive setting, even if the placement is outside the area, but still within the state of Texas. So we can make that amendment.
Okay, I just wanted to make sure we were consistent with the latest update from the Children's Commission, which to be fair was probably emailed after these were printed. But they were all very sensible. No big changes, just mostly to harmonize things within the family code consistent with changes that were made last session, more cleanup items, I believe. So nothing that's a huge change. Any questions on the Children's Commission recommendation package? Okay. The next bit of business doesn't have a legislative action associated with it. This is something that OCA is just gonna be able to work on. Americans with Disabilities Act. So each county has to have a plan for making the appropriate accommodations and having a contact person and basically complying with all the bureaucracy that is within the ADA. So typically the correct answer is if there's an ADA question to courts, there's a county plan or a county person who's the person who's in charge. But some things are courts dealing with every day, day-to-day, that counties maybe don't have front of mind. So interpreters, sign language interpreters, whatever it might be. And so it would be helpful to Texas courts to have just a an infographic or a pamphlet or a quick reference guide that if an ADA question pops up, that they have something they can put their hands on right in that moment. And so the recommendation is for OCA to develop, it says bench book, but it wouldn't be like a book, it would be like a short guide, so that court clerks and courts could have a quick reference on anything that they would need to be responsible for. Oh, and also model standards, again, thinking that that would be hopefully brief and not a huge bureaucratic endeavor, but basically the goal to be if an ADA question popped up live in court, that you'd have something you could put your hands on right away to know what you needed to do to accommodate. All right, Judicial Commission on Mental Health, they brought some items to us, and it has to do with mental health issues. So there were basically 4 different categories of mental health issues. One is emergency detention form. I guess the previous form was, I can't remember, too long or didn't have the information that was needed or it wasn't well organized. So they have proposed a revised form for us to approve. Also, some hospitals, when law enforcement officers were bringing a person in a mental health crisis to a medical facility, they weren't able to just drop them off and leave. The medical facilities were sort of demanding that they stay until the person was admitted. And so this recommendation would just be to clarify that they can provide the information and then return to their duties and that they don't have to sit there until the hospital completes their intake process. 3, clarification of court-ordered mental health services venue. I can't remember the details on that.
We also have a resource witness, Professor Shannon. It should be on the phone if anyone has questions.
Yes, I'm here. Good morning. That third one, Judge, is currently the venue has a rather vague term. It says that this court where the person is found when they're apprehended, and normally that works fine, but it doesn't if you have, say, adjoining counties and the mental health crisis center in the next county. So we have some language to try and clarify that venue could be in either of those counties.
Okay. And then civil commitment deterioration language for a person with anosognosia. Basically, that is a symptom of many mental illnesses where you believe that nothing is wrong with you. So part of the symptom of your condition is that you don't believe you have a condition. And so this would help get appropriate help for people in cases where they don't realize that they are experiencing deterioration. Did I say that correctly, Professor Shannon?
I think that's very good.
Okay. All right, any questions about the recommendations that were submitted to us by the Judicial Commission on Mental Health?
I just have one comment. Chief, on that recommendation with the requiring the officers have to stay sometimes hours waiting before they can leave. So I think that's really good, and I hope that the constables are included in that, because with our Justice of the Peace warrants, they cannot just drop and go. They have to stay for quite some time, I know. And so I think that recommendation is a great one.
So we don't have, Megan, we don't have a specific resolution. So do we vote on that JCMH or?
We do have a resolution, because the mental health, we put them all in one resolution and the Criminal Justice Committee has them. So we will adopt it once Judge McDerry does the other ones.
Great, okay. Sorry to step on Criminal Justice's toes on that one. Okay, next was supporting court personnel. So last session, there were, two updates. One is monitor the personnel workload study that was implemented last session. So last session, the legislature mandated a study of court personnel across the state. In other words, what kind of staff do courts have and how many and how are they using them? And that report is due, I believe, in November or December, I can't remember. So we don't have that data back yet, but in anticipation of the preliminary information, they've discovered, we're anticipating that especially in rural areas, rural courts are experiencing the same thing all other rural agencies are experiencing, which is short staff. So last legislative session, there was a grant program for rural prosecutors, rural sheriffs and constables, am I recalling correctly? Okay, and so this session, we are recommending that we do the same thing that they did last session for those three groups, but also for rural courts, is that correct?
Court staff, yes.
Court staff. So basically copy and paste, but add courts to the prosecutors, sheriffs, and constable grant program that the legislature did last session. Any questions on the court personnel issues? Okay, and then the last group, again, no legislative action on this AI area, but this is something that is a hot topic right now that everyone's really interested in, and there are definitely some good and bad things or blessings and concerns that we have for our court system. So our first recommendation is for the Texas Supreme Court to consider rules for local courts about acceptable use of AI by court staff. So for example, we wouldn't want court staff hearing about a cool new AI tool and uploading confidential or private information from the court into the public, cool new AI tool. So having some guidelines for court staff on how you can use your data with AI tools would be helpful. The second recommendation was education. So we all hear the headlines about people not realizing that AI can just invent information. It doesn't just report, it creates. And so for judges to evaluate the cases in front of them, the briefing, whatever, that they need some education on the benefits and risks of AI use. And I believe I saw later on that somebody had a change in wording, which I think we all agree on, which is instead of making this a separate category of hours that judges have to obtain, which we already have enough categories to keep track of, that this just be added to, for example, the Texas Center for the Judiciary's programs that they're already putting on, ask them to add AI training to them, which I think would be extremely helpful for judges. Another cool thing that we heard about in our committee, and I can't remember if the bigger group has heard about it, but clerks' offices, so all of clerks' duties are, they don't have discretionary duties. All of their stuff is very, what is the word I'm thinking of?
Ministerial.
Ministerial, thank you. Yes, so since all of their duties are ministerial, they lend themselves very well to being programmed into an AI process automation. And so, for example, specifically, I believe it was Tarrant County had an AI program that would take all the court filings coming in and process them with entering in the data into the correct blank and reviewing that certain things were present. And then a human being would check it and confirm it. But I think I'm might be misrepresenting these numbers, but it took the filing time down from 2 minutes per document to 30 seconds per document or something. And so it really was a rapid increase in efficiency, especially with clerks' offices being short-staffed, having this type of automated process, making their work more efficient would allow them to keep up with their workload. So that has gone very well in Tarrant County, and so our recommendation 3 is to seek funding to expand that use across the state for certain ministerial tasks that can be done by a robot and checked by a human. The fourth recommendation is we hear anecdotally about people using this or that AI tool and it helping or not helping, and so it would be helpful for OCA to kind of do some information gathering on what AI tools are currently being used across the state, and so we could share that information or avoid things that should not be used. Lastly, we had a recommendation for the Supreme Court to consider whether we need changes to any rules to address the fact that evidence can be manipulated through AI. And it's, we don't want to be overly fear-mongering about it. Certainly evidence has always been able to be faked. The specific concern that we might want to take a special look at is AI allows you to bulk fake evidence in a way that hasn't really been plausible before. So that is just our recommendation at this point, to just take a look at the rules and see whether AI requires any different treatment than any other fake evidence that we've always, come across. Any other questions or discussion about those topic areas, which again are summarized in this packet with the blue at the top? Okay, do you want me to go ahead and go through and vote on these or wait until other committees have gone?
The civil justice recommendations now.
Okay.
And can we go together or do we?
We can, so unless, so it's resolutions 2, 3, 4, and 5. And then the civil justice, those include the recommendations that Justice Miskell just discussed.
Okay, so 2 is streamlining the overlapping jurisdictions. 3 is the stuff about local administrative judges. 4 is Texas Children's Commission. And 5 is the grant fund for rural courts. So can I move?
May.
Okay, so I will move that we adopt resolutions 2 through 5. Is there a second? Okay, any discussion on any of them?
Yes.
Go ahead.
On resolution 4, we're deleting number 8, right?
Yes.
Yes.
Okay.
It is, so we can, if you prefer, we can hold that one until, but the other committees made the same recommendation. So, yes.
Fine with me.
Okay, so with the friendly amendment that number 8 on resolution 4 is removed, any other discussion on 2 through 5? Okay, all in favor? Any opposed?
I am.
Was that an aye?
I think it's a delayed eye.
Okay,
I said I.
okay, because I said any opposed and then I thought she might have said I am.
No, I'm sorry. I'm voting in favor, not opposed.
Okay, okay. All right, so that is the end of civil justice, and then I'm sorry you get to listen to me again because I am your Bill Gravel today. He unfortunately was not able to be here, but first of all, he wanted me to extend thanks to our legislative members, specifically Senator Zaffarini, who's been so dedicated on these 2 committees, and thank everybody for their commitment to our justice system.
Where is Judge Gravel?
I can't remember what he
He's in
said.
Korea.
That's right.
Yes.
Why can't he be here from Korea?
He's in the Williamson County office.
Yeah, that's what I was gonna say.
He wanted to be here.
Yes, he is.
Yeah.
Okay, so data committee. So we have some things about, we're gonna talk a lot about Research Texas. So background on Research Texas, Texas went to electronic filing a while ago, but we have not had any type of centralized library of all the electronic court documents. In the federal system, they have something called PACER, which you can log in and kind of search documents and get everything, and we just have not had that in Texas. But so one of our charges is to investigate how we can provide a Texas version that is useful and makes sense for the way our court system works. So we have a couple of recommendations about Research Texas, about certain modifications that can be made behind the scenes to improve its usability. So for example, if I find a good document on Research Texas and I want to tell Judge Maderi, hey, take a look at this, we don't have like fixed links for the documents. So I couldn't send her a link that goes directly to that document so it can pop up for her. And so one of the recommendations is to make, I forget what the word is, it's probably in here somewhere, but like fixed links so that you can easily share the documents. There was another, what were the other usability? Like maybe like if you want to just download every document in a case, instead of having to click each one individually, you could just have a select all and download it in a bulk. Just minor changes like that would make the experience of using, one of them was to, right now, each attorney has to pay individually for their transactions. Whereas if you're in a firm, it might make sense to just get that all on one invoice, right? So some of these just minor usability changes, that's recommendation 1. Recommendation 2, we have some conflict with our rules about, we have one of our rules of civil procedure talks about sensitive data. and it says that attorneys are not supposed to be putting sensitive data in their pleadings. They're supposed to be redacting. But if for some reason they can't redact and the sensitive data is required by law to be in there, then and only then they can put contains sensitive data at the top and it won't be available online. Well, there's no incentive to do that process correctly. And so the thinking of attorneys is, oh, well, I don't want to get in trouble for putting sensitive data. I'll just put notice contains sensitive data on top of literally every document that I do. And like the Attorney General Child Support Division puts it on at the top of every page of every pleading. And so we have whole swaths of documents that are supposed to be available on Research Texas that are not. So this is an example of a rule change that might be needed to make Research Texas work the way it's supposed to be working. So that's recommendation 2, is to study how our court rules are interfering with the functioning of Research Texas and to see whether they need to be fixed. The second category has to do with clerk's record. So one of the changes we got last session was now parties, there's an option. So when you appeal a case, I think in the federal system, the whole file just automatically goes from the trial court up on to appeal. That has never been the way we've done it in Texas. In Texas, the parties are responsible for picking what documents they want, telling the clerk, and then the clerk submits the documents. Last legislative session, we got a change that parties can either continue to do it that way, or they can submit their own record that they assemble themselves. And so that's just started to go into effect, and so we're just starting to see people choosing to do that or not do that. But this recommendation is to see whether we need any further modifications to the rules of appellate procedure to streamline the submission of the clerk's record. So, for example, using research, maybe we could have a one-click and go option. One thing we need to be mindful of is the clerks get paid per page to do this, which funds their office. So we also need to be sensitive to the fact that there are many stakeholders in this decision. But to the extent the rules of appellate procedure are a block to things functioning the way that they need to, we need to take a look at that. Court activity reporting. This is a resolution and there is a expense for this one. So we have more and more data that courts are collecting, more and more electronic systems that they're tied into. So you've heard me talk about e-filing, Research Texas. You've heard this committee talk about case level data before, which is being implemented. So we have a lot of very specific technological tasks that we are putting on courts, and OCA has not had the staff to provide one-on-one assistance to how to implement them. It's getting to the point that the regional presiding judges are reporting that this is a lot of work, and it's gotten to the point where we need actual employees. So resolution 6 is for each, how many regions is this one? 11 regions. So these are each of our administrative regions. We'll have one full-time employee that will be a data coordinator, that will be the person that can integrate all this technological data, make sure the counties are set up to report, making sure that they are reporting, that the reports are correct. You'll hear more about the reporting, I imagine, as we go through this, probably from criminal. But there are a lot of reports that need to be submitted, and those take a lot of time. So this resolution is to create a full-time employee for each of our administrative judicial regions to do this court data collection, data reporting, data implementation, working with the software, all of that. I asked in our committee meeting, do we really need a full-time person for each region? Like, could they share? And the answer really was, especially with our case level data implementation coming up, that we anticipate that for the next good bit of time, there is going to be plenty of work for each region to have a full-time staff member to do that work. Megan, was there anything further you wanted me to say on that?
So they would be OCA staff, but would be based in each of the regions. So, and the thought process.
For you, but help each individual region?
It helped the counties and the clerks in those regions. So the thought is that if we had one based in each region, they could get to know the clerks in their region, the case management vendors that operate in their region, and develop those relationships. And so they're really supposed to help not only the clerks, but also the judges with all these new reporting requirements. So training, making sure that the data is accurate. We've had dozens of counties contact us and want us to come out and go through their case management system and go through their data to make sure that they're reporting accurately, and we just don't have the staff to do that with over 450 clerks' offices in our state, just at the district and county level. South Carolina has set up a system like this. We heard about it this summer, and they've had really great success in making sure that their data is more transparent and timely, and so we think that this will make a big difference.
And especially something that Judge Gravel brought up in the meeting, which was we don't have a requirement in Texas that all counties have to use the same case management software, and so counties don't. And it's a whole other game dealing with the case management providers. So any little change you want, you request, hey, we need to check this box or we need to change this box so that we can do our reporting. And they're like, we are happy to make that change for you for $40,000 or whatever it is. And so it's a constant negotiation. Or they'll say, well, if you upgrade to the new version, then, you know, and then you have to like go through the testing and the updating. And it's just a whole separate game on that side for dealing with the case management vendors. So
Megan, would they have to have a IT background?
I mean, I think it would be helpful. We are, Casey's like, yeah. I think it would be helpful. What we are seeing is, so we have former clerk, Sherry Woodfin from Tom Green County is on our staff now and works with our data team. And she goes out and sits with the clerk and the clerk's staff and goes through and says, you know, 200 cases should have been closed in 1997. I mean, and they're still showing up as active cases on a judge's docket. And now with case level data where we're reporting by court, that's going to show up again. And there's going to be a lot of unhappy judges when the data is not accurate. So she's been doing that and has gone out to several counties, but she can't. She's one person. And our data team has, I think, 6 staff total and just can't hit every county. And so we think too, there's House Bill 2384 was passed last session and now requires the regional presiding judges to review this data and to provide resources to courts that are not meeting performance measures. And so we think that these data coordinators can also be liaisons to the regional presiding judges in helping them know what's going on in their regions.
And the reason I asked that is that in Dallas, our justice of the peace courts, we were able to get an analyst, and she's amazing. I know Michael met her, and she's been able to go through all of the 10 courts to do those very things about reporting data here and making sure that everybody's information is updated or conversion. And she meets with our vendors. We send her to Tyler Technologies thing. So I think that's a great idea. It's going to be very helpful when everybody has that in their region. So
we've seen a need for having liaison between the counties and the vendors too, because sometimes there's a disconnect in, you know, deadlines, what is required, and having people that understand the different case management systems is also would be very helpful.
I did not realize behind the scenes how much work these case management systems are, and like the slightest little change, first of all, costs a lot of money, but then you have to have, luckily if you have an analyst, you have someone who can do the testing, who can do the rollout, installation, train everyone, like, but a lot of counties don't have the resources, I'm sure, to have that type of analyst, so.
And the one is always not sufficient. It's not enough personnel, you know?
Right.
You always need more hands, so.
Okay.
Test it ahead of time so you don't run into a train. Yeah, any change.
The last item is judicial information for the public. So this is not Research Texas. This is actually something a little bit different. But basically, we have a lot of the things we do assumes that courts have websites, right? And I've probably been in a privileged, Collin County had a county information officer, and I would just email him when something needed to be on the website. But in smaller counties, it's not that simple. And so the suggestion was for OCA to either provide a template or to host like a basic website for a court that you could provide all this information that we're wanting courts to provide to the public, like how to, show up for your hearing, how to submit exhibits, what all these things that we're saying should be on the court's website. Well, now for smaller counties, maybe we should have a template or a host, a basic website for them. So that one doesn't have any, that's just a resolution for OCA, right?
Yes.
Yeah, just a
Okay.
recommendation.
Just a recommendation that OCA provide that, either a template or host a basic website for local courts that don't have that in their county already. Any other questions on the data topics? I think the only one that we had a resolution on was the regional data coordinators, is that right?
Yes.
Okay, so I will make a motion that we approve resolution 6, which is for those 11 positions for the regional data coordinators.
I'll second.
Okay, any discussion? I'm sorry, did I jump ahead?
No,
Okay.
that's perfect.
Any discussion on that one?
Do I not have to not vote on that since it's helping the PJs out?
I mean, you can vote present
Abstain.
if you want.
Okay,
Do
I mean, all for it, but.
I don't think it's a conflict.
Okay, then I vote for it, aye.
Yeah.
Okay, any other discussion? All right,
I have a question. Any kind of training involved or quoted or priced in terms of budget for that?
okay, so 2 questions. Are we mandating any type of training, and then what is the budget for that?
So the request that we have made, it's a little over $1 million for the staff. And then we would provide the training to the staff and get them up and running in each of the regions. So besides that, there wouldn't, there's no other budgetary request besides asking for the staff.
Any timeline on that?
So it's a legislative request, so if it does get funded, it would go into effect September of next year.
Any other questions, comments, discussion? All right, all in favor?
Aye.
Aye.
Any opposed?
You learned.
All right, that is the end of my portion.
Then we'll go to criminal justice, Judge Malary.
I'm gonna have Judge Miskell do my report. All right, so let's talk. We had the Criminal Justice Committee, we met April 3rd, June 17th, and August 30th. It felt like we met a lot more than that. We had 7 charges that were covered, enhancing court security, court efficiency, bail, and preventative detention, to monitor Operation Lone Star, monitor court personnel workload study, which is the joint charge, as we talked about, with civil justice and public trust and confidence, judicial terms, and then associate judges. So the first is enhancing court security. Court security continues to become, or to be at utmost, priority. Just this month, although I'm still trying to Google and find out really what happened on that case, the Kentucky judge was killed in his chambers. We had 6 people that were injured in an incendiary device in a California courthouse. There was a plot that was uncovered to kill a Williamson County district judge here in Texas. We heard from the federal and other state legislation to restrict and remove personally identifiable information for judges. And then enhancements are also needed for certain crimes against judges and judicial employees such as harassment and terroristic threat. So recommendation number 1, the legislature should pass legislation to prohibit online data brokers upon the request of a judicial branch officer or court support personnel from posting and distributing online the personally identifiable information, PII, of the person affected. The legislation should authorize the Office of Court Administration to act on behalf of affected persons in coordinating the removal of judicial PII with online data brokers. Now, we were recently at a seminar about 2 weeks ago, and they sit out there with all of the products that they want us to look at. But what was very interesting was one of my judge friends went over to what was the name of that company for the PII?
It's called Delete Me.
Delete Me. And he said, let me, just give you an example of how, trackable you are, right? And so he put in a name of his brother, and just like anyone else. And it came out with so much information. I mean, where he went to school, where he lived, just everything that you could possibly not want to have listed. And then he's
Family members.
yeah, family. I mean, it was really incredible. And then he had already done the Delete Me on his name there. And he said, this is what you do when you find me, right? And there was nothing. There was nothing everywhere. And so they go in and it's basically, they go in and it's like anywhere, you know, that you're mentioned, anywhere that you have anything, they, you know, they delete it so that it's not there. So that was kind of an interesting thing. Recommendation 2, the legislature should amend various statutes to enhance penalties for crimes occurring at court facilities or crimes committed against judges and judicial personnel. Recommendation 3, the legislature should pass legislation protecting the personally identifiable information, the PII, of court support personnel maintained by governmental record holders for disclosure. So this is also, you know, the individuals, it's kind of like, you know, your family and the court coordinators and everything like that. So that would be that. The 3 recommendations are incorporated into resolution number 7. Next, we went into bail and preventative detention. We have, TJC has, you know, recommended reforms to provide judges additional tools when considering and setting bail, and we're always looking at this type of thing. Committee is recommending enhancements to the public safety report system. Those will be in recommendations 1, 2, 3, and 5. The committee recommend the legislature amend Article 17.151 to provide judges additional discretion when setting bail for violent felonies if the state is not ready for trial in 90 days. That's recommendation number 4. Committee is again recommending preventative detention for certain defendants charged with violent crime after certain findings. That's in recommendation 6. And the Senate Committee on Criminal Justice held interim hearings in June on charitable bail organizations. The committee is recommending some additional data collection for those organizations, which is incorporated into recommendation number 7. So recommendation number 1 is the legislature should amend Article 17.021B Code of Criminal Procedure to make enhancements to the public safety report system to expand report notifications to include prosecutors, clerks, and if possible, defense counsel. Recommendation 2 is the legislature should amend Article 17.021B Code of Criminal Procedure to allow for an enhancement to the public safety report system to flag defendants with protective orders, probation, parole, and any other warrants. Recommendation 3 is the legislature should amend statutes to require a bail form be completed within the PSRS if the defendant is released in conjunction with a general bond order. Recommendation 4, the legislature should amend 17.151 Code of Criminal Procedure to create a tiered released timeline based on the severity of the offense. And what we were thinking in regards to this one is, you know, we all hear, well, a lot of us hear, where someone says state's not ready for trial, right? State's not ready for trial. And we have the same amount of time before they have to be released. And so what our committee was thinking is, you know, everyone in our committee thought, you know, there's quite a difference between a possession of controlled substance case, right, and an aggravated robbery case. And sometimes the aggravated robbery case, you know, we don't think that they should be treated equally, right? Like to be released after 70 days or 75 days or 90 days. You know, a POCS case is to us a lot different than an aggravated robbery or aggravated sexual assault where they're still trying to get, you know, evidence and that kind of stuff coming in. So that's why we kind of were thinking about that. Recommendation number 5, that was 4. Recommendation number 5 is the legislature should provide funding to counties to allow local case management and jail systems to integrate with the public safety report system. Recommendation number 6, the legislature should amend the Texas Constitution and enact related statutes to provide that certain defendants charged with a violent crime and posing a high flight risk and or high risk to community safety may be held in jail without bail pending trial after certain findings are made by a magistrate and a detention hearing is held. Recommendation number 7 is the legislature should amend 17.071 of Code of Criminal Procedure to require charitable bail organizations to submit to the Office of Court Administration the annual affidavit and the monthly report required to be submitted to local government officials by Article 17.071. The legislature should further amend Article 17.071 to require charitable bail organizations to provide more detailed information about defendants in the monthly report. The 7 recommendations are incorporated into Resolution 8. So we have Judicial Commission on Mental Health. We have Professor Shannon on the phone if any has questions on that. The resolution is number 9, and it's Texas Judicial Council urges the legislature to enact the recommendations from the Texas Judicial Commission on Mental Health concerning the following areas: emergency detention, civil commitment, early identification and referral to treatment, and specialty courts competency restoration and court-ordered medication. Associate judges, the committee heard about, and we talked a lot about this, and I think this is a, isn't this a joint charge with you all, as on the associate judges?
Yes.
Okay. Committee heard about many types of non-elected judicial officers, right, including magistrates, masters, referees, assigned judges, hearing officers, criminal law, hearing officers, and associate judges. Now, the hardest thing was trying to determine what these actual people did, right? And what was the difference between somebody in Nueces County who might be called a magistrate, somebody in Calhoun County might be called a referee, and what type of things do they do? So that was our first time figuring in that. The committee agreed that additional studies warranted, but standardizing the minimum qualifications regarding years of experience as a licensed attorney would be a good start. So recommendation number 1 is that the legislature should pass legislation to add minimum qualifications regarding years of experience as a licensed attorney for magistrate positions under Government Code Chapter 54 that do not currently have a minimum requirement. We thought it was a start. I think that some of us feel like it should go a lot farther, but it is a start. Recommendation number 2 is the legislature should pass legislation to increase and standardize the minimum requirements for years of experience as a licensed attorney for associate judge positions created under the Government Code Chapter 54A. The committee, we talked long and hard in regards to these. We are making recommendations to the full council to adopt the associated legislative resolutions and the committee reports. And with that, Chief, I'll turn it over to you or to Megan.
So is there a motion to adopt the report and resolutions 7, 8, 9, and 10?
Second. I'd like to be shown voting, present, not voting on 8.
On resolution 8? Yes.
Yes. On 7, I'd like to put forth an amendment to add after the second page on the actual recommendation down there, after judicial branch officer, district or county clerk, because we're in the courthouse security protection, but leaving us off of this would be maybe not a good idea.
So, what, can you say where that is again, Mr. Kimball?
Resolution number 7, page 2, last paragraph. It says, pass the legislature prohibiting online data brokers on the request of a judicial officer. And then just add in district or county clerk or courthouse support personnel.
Was your question that you think court support
I
personnel
was
is not
I was trying to add that as an amendment.
Yeah, but
So,
just to
yeah.
say that that would not be specific enough, you think, to include the clerk staff?
Well, we're not a judicial officer.
So have a court
So I'm
support
not sure, and
personnel.
we're an elected official, so I'm not sure we fit under staff.
Oh, right.
So just
the
add in
clerks
district or
themselves.
county clerk, so it's clear.
Include all the city.
Well, we're
Upon the request of judicial branch officer, district or county clerk, or court support personnel, is that?
Or court.
That's what you're asking
Yes,
to,
ma'am.
for the amendment. Chief, does anybody have, we'll accept the amendment. Do I have a motion to accept it?
So moved.
Okay, second?
Second.
All right, so as is, it's amended, Chief.
I know this piece of legislation is of great interest, and it did pass, I think, it got caught up in the, with the governor over the vouchers, I think, so. I know a lot of people want to support this and expand security, so.
Any other discussion? And all in favor of the motion as amended? Aye.
Aye.
That carries.
Yes.
Yes.
On 8, Senator, thank you.
Chief, I think we need to go back and, we didn't adopt the civil justice or data committee reports.
Okay,
So we
Yes,
go
is
back
there a
and do
motion
that.
to do that?
I'll move.
Second,
I'll second it.
discussion.
We adopt the agreement.
let's,
More than
let's
votes.
do them just to make sure.
Yes, all in favor of the motion to adopt the report?
Aye.
Opposed? Done.
And then criminal.
And then do criminal, yes, just to clarify for the record.
I make a
The
motion to
report?
adopt.
Yes.
Yeah, the criminal justice.
So there's a motion and a second, any discussion on adopting the criminal report? All in favor?
Aye.
Opposed? Right. That takes us,
Judge Maderi just volunteered to. And I'll try to remember at the end, all that.
that takes us to public trust and confidence, Judge.
Thank you, Chief Justice. We met, April, July, September, 3 times, and we have 8, charges, 2 of which we've, had some joint resolutions. I'll just go through the charge with what we did. Charge 4 is addressing, judicial profession shortages, and the last session, the legislature, created an additional 30 courts. There are many more courts too out there in the municipal world as well. But the number of certified court reporters and licensed court reporters has declined by at least 15% over the last decade or so. So we have 3 recommendations to try to help with this decline. Recommendation 1, the Judicial Branch Certification Commission should accept the National Court Reporters Association Registered Professional Court Certification and Registered Merit Reporter Certification in place of taking the Texas examination. Recommendation 2, the Judicial Branch Certification Commission should regulate digital court reporters and recorders. Recommendation 3, the legislature should fund an expansion of the remote court interpreter program to help meet demand for the program's services. And recommendation 4, OCA should increase interpreter training, continuing education, and pre-testing orientation skills. And we did hear testimony about how a lot of the problems is the lack of training. People take the exam, fail, they don't even train before that, and then give up. So especially Spanish interpreters, that's obviously a big need. So recommendation 2 and 3 are incorporated into resolution 11. Anything about that? Our next charge is the Centers of Excellence, which we'll hear about too later. It's charge 7. The Centers of Excellence continues to be a very successful program. We've had 8 courts deemed a Center of Excellence, I believe. We'll hear about a 9th, I hope, today, right? And so there's 10 courts right now that are in a stage of review and wait list. And so we heard about opportunities to enhance the program. We have 3 recommendations. Recommendation 1, the Center of Excellence initiative should identify and develop separate review and valuation standards for each level of court that reflects unique requirements of their specific jurisdiction. The initiative should also incorporate new court performance standards mandated under House Bill 2384 in the 88th legislature. And I know Michael's discovering as he explores like municipal courts and JP courts, that the courts are very unique, but it also would help if we have specific standards for each court, other courts to try to meet those standards. Recommendation 2, the Centers of Excellence initiative should establish recognized courts and judges as mentors and ensure that their technical knowledge and best practices are shared throughout Texas. To bolster participation, the initiative should provide template materials for public press releases, proclamations, and relevant languages for plaques and recognition at the local and state level. So again, use the the people who have courts that have been deemed centers of excellence, use their skills and encourage the use of their skills throughout Texas for others. And recommendation 3, which is incorporating a resolution 12, the legislature should fund merit payments for jurists, judges whose courts are recognized as a center of excellence. Any questions on that? All right, judicial emergency management readiness. The Task Force for Judicial Emergency Preparedness 2017 report Since that's come up, we've dealt with a pandemic, fires, flooding, cyber attacks. And our OCA Court Security Division, we heard from them, they're well positioned to create and review preparation plans while also working with the local court security committees. We wanna kind of bolster and maybe give some more specifics to what local court security committees are doing. I know a lot of city and counties have, I think it's called a COOP plan, a continuing of operations plan. But we wanna make sure that courts have their own if they don't have a plan. So recommendation one, the Texas Judicial Council should encourage the Supreme Court to continue to implement the recommendations found in the Task Force 2017 report and leverage the OCA Security Division, Court Security Division to further this implementation. Recommendation two is the legislature should amend various statutes to require local court security committees to implement an all hazards plan for local courts. And recommendation three, the Court Security Division of OCA should develop a model all hazards plan that can be adopted by local court security committees. And that second recommendation is incorporated into resolution 13.
Sounds like you're adding more tasks for the local administrative judges. To make sure those go in the handbook.
All right, improving access to court, which is our charge one. And this, we actually spent some time, quite a bit of time on this and we heard about challenges for indigent court participants, including sufficient attorneys to meet demands for counsel and transportation to courts. And then we also heard about magistrate proceedings, the unique challenges in terms of the open courts provision because of timelines for completing the hearings, the type of facilities where they're held, which is mostly jails. And so we thought that we would have an opportunity for a best practice guide. So on that, and we just heard from the Civil Justice Committee about recommendation one, I believe the Office of Court Administration should develop an ADA bench book for use by courts and clerks and should develop model ADA standards for adoption by courts and clerks. I know like Travis County has a good bench book, but a nice ADA bench book for all of us is a recommendation we have. Recommendation two, the legislature should establish a loan repayment program for public defenders and private attorneys serving indigent clients facing criminal, juvenile delinquency charges or representing children or parents in child welfare cases, similar to the Physicians Education Loan Repayment Program. And we heard a lot of the programs that have worked in terms of having fewer physicians made sense in terms of lawyers, and there has been a decrease in, especially in rural areas, which are not always, still have populations in Texas. There's been a decrease in terms of the attorneys available for appointment for indigent defendants and specifically these type of cases. Recommendation three, the Texas Judicial Council should create a best practices guide for magistrates on open courts. And then recommendation four, the legislature should pass legislation to encourage counties to provide transportation for indigent litigants to attend courts and establish grant programs to assist fiscally challenged counties with the cost of court transportation assistance program. And finally, recommendation five, the Texas Judicial Council should encourage the Supreme Court to explore expedited license options for attorneys wanting to gain a license and their license in other states, performing public service work, including public defenders, attorneys taking appointments in indigent, criminal, or juvenile cases, and attorneys taking appointments in family protection representation. All right, our next charge is civics education. We heard from the Chief Justice that, now I think more than half have expressed somewhat unhappiness with the courts. Well, there's also, we heard about a 2023 Annenberg public policy study in which 1/3 of the US adults that were polled were unable to name all three branches of government, and 1 in 6 could not name one single branch. And I hit this too when I talk to our college kid defendants, they do not know. They do not know their branches.
That's so sad.
Yes, it is sad. I mean, literally don't know. I bring up Batman or other things, they don't know. They don't know. The committee believes that the public must be further educated on the differences between the judiciary and its sister branches, and how we were designed and how courts operate differently also, and why they're separate from the other political branches. So recommendation 1, which is incorporated in our resolution 15, the legislature should amend state laws to require comprehensive civics education that includes an emphasis on the judiciary, its design, and how the state and local court systems operate. And I think we've tried this before, right? So we're gonna try to get that again. And recommendation 2, the Texas Judicial Council should work with the judiciary to establish a judicial civics education center. And we heard from several states that have one. I think Colorado and there's a number of states working on that. All right, then charge 8, the final charge that we worked on that's unique to our committee was the Judicial Conduct Commission. We heard from the executive director, Jacqueline Habersham. The committee heard from this about the processes and resources that they have. The last legislative session, there were several bills reforming judicial conduct. It is clear that the Conduct Commission needs adequate funding to carry out their current and future duties. We have resolution 18, which is to support adequate funding and resources to the State Commission on Judicial Conduct.
So we have, 4, and resolutions 11, 12, 13, 15, and 18, and accompanying. Is there a motion to adopt all of those?
So, Chief, I have a,
Oh, I'm sorry, left off 14. Go ahead.
so I just didn't wanna be voted on yet, but the Center of Excellence, and I think I've spoken to a couple people since this, and I've been speaking with Michael also. You know, I'm all for a merit pay for the judges. I mean, it's hard, right, to go through the Center of Excellence, it's hard. However, I think it's going to kill the Michael. I mean, I don't know if all of a sudden, and I don't think judges really realize how hard it is to become a Center of Excellence, but what worries me is that Michael's gonna get 500 people that are gonna come and be trying to be centers of excellence, and that will overwhelm that department. And so I was trying to think about what's a way to do that, right? And it's just like, you know, I was talking to him and trying to think of a way to do this, and you could have like a wait list, right? And you could say, okay, and Michael and I have talked about this, whether or not they can take on 10 a year, 12 a year, or 12 at one time, right? Or 15 at one time. And then if one becomes a center of excellence, then the next one on the waiting list pops up and comes on there. I think that if the judges hear about this, you know, they might all go, oh yeah, I wanna become a center of excellence, having no idea how difficult it is, right? And also how, I mean, there were times when I was going through it that I was like, I don't know if I can do this, right? And just kind of stopped, you know? And then, you know, you keep working with Michael and you push through and it's all for the betterment of the court. And so you push through to get it done. And I don't think the judges realize that. And so if all of a sudden they say, oh, I'm gonna be on this, you know, list, and then there's 500 on there, I think that will hurt what we're trying to do with the Center of Excellence. So that's just my 2 cents on this, that I think that it should be limited. Michael, do you have anything on that one?
I mean, so we've been having internal discussions between Jeffrey and myself about what is feasible in a year. We currently have 10 active courts, and we don't think right now more than that would do it, just to be honest with my time on the project. So a wait list was already sort of informally in the works, and we were already in conversations with judges about here's where you are, here's who's ahead of you. It's self-driven. You do this as fast or as slow as you can push through the process. So I don't have any comment beyond a wait list is a good idea. And if it does get out, yeah, I would consider that we would have a significant uptick in interest across the states.
I had some concern.
Obviously, to have merit attached to it, there has to be legislation. Senator Zaffarini did file that last session. I think, yes. What we would do is, along with what that merit would cost, the fiscal note for that, OCA would likely add a fiscal note for additional staff to support the program.
Didn't you get 50? 50 at a time.
Well, then it's a good problem to have, because
Yeah.
we don't have that problem right now.
Yes.
And if we were to pass the bill, we didn't last time, we didn't even get a hearing, but if we were to pass the bill and if we were to get funding, and if we were to have a situation where we ran out of funding, we could always ask for emergency funding or budget execution authority. Should we come to that, somehow I doubt it.
Yeah, there was a lot of ifs, right?
Yes,
Right.
but I think it's a great recommendation.
Oh, I'm all for it. I just want to make sure Michael
Yeah,
survives.
I mean, obviously, we'd have to do.
I'm not worried about mine.
Poor Michael. Michael, here you go. Love to you.
Get some bot Michaels.
That's right, that's the part of the AI portion of the.
I'm gonna have to go through the AI thing and figure out what tools I can use, yeah.
Use discretion where you don't.
So to be clear, Megan has corrected my list. We need a motion on the report, resolutions 11, 12, 13, 14, 15, and 18, and the recommendations. Yeah.
I move for the approval of the recommendations made by the Public Trust Committee.
Is there a second?
Second then.
Further discussion? All in favor? Aye.
Aye.
Opposed? Okay, that carries. I'm sure you all know that Senator Cornyn's security bill passed the Senate unanimously in June. And it's been in the House since then. Representative Sheila Jackson Lee was one of the sponsors, the late representative. And Representative Mike McCall here from Boston was a co-sponsor, and there's some others that are signed on. It's very much bipartisan in the House. Representative Doggett has expressed support for it. It's been tied up with the continuing resolution and the budget issues, but we got word just 2 days ago that the leadership is willing to move it in a lame duck session. So we think it's going to pass before the end of the year. That hardly ever happens, that a bill passes both houses in the same session. And there'll be funding attached to it at some point. It's not there yet, but it's moving along. And there's been a lot of talk around the country about kind of the general issue. So these are very timely issues. And we're a little bit ahead of the curve because we have the Kasuric bill that we passed several years ago. But this will provide further federal support and help with security.
And I think Senator Cornyn is, and I had talked with, or emailed with Nina, they're doing like a touring around, right? They're having it in Dallas and everything. And so Nina had reached out to me to see if I could talk to them in regards to the one that they're gonna have in Brownsville. And so at the same exact time I got your email, one of my district judges down there called me and said, hey, we thought this was just gonna be like 4 or 5 people, but they're gonna come down and do like 15 people and do a round table. And so they've invited me to do that as well. So I'm gonna go down there, Chief, and try to bring some other individuals. Because I think we all have stories, you know, I mean, I have, right now, currently, I have a protective order against an individual that threatened me. And I didn't really, you know, I mean, it scares me, right, because I have kids. But, you know, I have a 2-year protective order on me. And so I had another individual, you know, that called up, and I think this is what they want to hear is these type of stories and what's happened. And so I reached out to a couple of my friend judges, and I'm like, have you been threatened? And, you know, kind of finding out. And it's really funny because, you know, they're friends of mine, and I didn't know half of the stories. I had another guy said that as soon as he gets out, you know, he's gonna put me on suicide or death penalty or something like that. And so those type of things. And I think, you know, we had some issues down in Brownsville that it happened as well. So I just am happy to report that I'm gonna be going down there October 15th for that.
The Dallas and Austin meetings had the usual participants, the Judge Kusurik, but also other judges, prosecutors, and law enforcement. The Austin meeting had a criminal defense lawyer who said, well, it's not just on the prosecution side, it's on my side. And as soon as the guy loses, I'm the reason he lost. And so it's, you know, we just live in a very volatile age.
And justice of the peace too, Chief. So I
we
think,
will.
like Judge Maderi is saying, I think a lot of people have a story. You just don't really talk about it.
Right.
Yeah.
Okay, that takes us to full council resolutions. Megan.
So I'm looking at resolution 16, 17, and 19, and these are resolutions that the Judicial Council traditionally passes before every session. Resolution 16 is to support the recommendations from the Judicial Compensation Commission. They did recommend a 30% increase to the base pay for district judges, and that is just to keep up with inflation. They also recommended to create a third tier within the present judicial compensation structure to provide a mechanism for cost of living increases. And then they recommended that an appropriation should be made for the judicial administration specialization certification that was passed last session. And it is in statute that a merit payment can be provided for that, but that was not funded by the legislature. So that's resolution number 16. Resolution number 17 is just a general support for maintaining the funding and resources for civil legal aid. And then resolution 19 is an all-encompassing resolution to support adequate court funding. So this includes all of the legislative appropriation requests for the appellate courts, the 2 high courts, and all of the judicial branch agencies, as well as supporting education and funding for education for judges. Also in there is support for civil legal aid, and then support for indigent defense. And so those 3 resolutions, historically, the council has always passed. And with that, I will move that. Or Chief, I can't move, you have to move.
So is there a motion to adopt resolutions 16, 17, and 19? Second? Any discussion?
I did have a question on resolution 16, number 4, which is the judicial administration specialization. So the bill that passed last session said that the legislature could appropriate additional compensation for judges that have a specialty certification in judicial administration or any other specialization. So we're recommending, I know in informal discussions with other judges who are already board certified in a different specialization, we're like, oh, okay, well, everybody who's certified in anything will get the raise, not just if you're judicial administration. But this request is specifically to appropriate only for judicial administration specialization and not if you're already certified in civil trial law or something.
That is what the Judicial Compensation Commission didn't look any further. That is the only thing that they looked at. And so we could amend it to say any
I was not proposing an amendment. I was just asking a clarifying question about if you knew why that was.
Yes, this just tracks what their recommendations are. The only recommendation that is not in here is delinking legislative retirement from the base pay of a district judge, because historically that has been a very controversial topic, not only in the legislature, but also with the Judicial Council. So that's the only one that was left off of there. So we could do a motion to add that.
I wasn't proposing a change. I was just clarifying, like, that's on purpose.
I don't think that they just looked at what was already in her testimony about 2384 at their public hearing. And so that's why they decided to include it. They didn't hear testimony that other specializations could be included. I don't want to speak for the Compensation Commission, but I think if they had heard testimony that other specializations could be included, that for their recommendation, but because it wasn't
The
addressed.
text that the legislature passed, I was
Yes.
just curious.
Yes,
I can still consider it.
yes, they could.
Other discussion? Then all in favor of the motion, aye.
Aye.
Opposed? Carries. So that takes us through the committee work. And then, as you know, yes,
I'd like
Senator.
to thank everybody who worked on these excellent reports. This is really excellent work. I was very impressed.
Thank you.
And thanks to everybody, especially the staff
Yes,
and the
absolutely.
chairs of the committee.
The council pay is not very high, and people give a lot of their time to work on these things. I know it's a labor of most instances, but also of expertise and vision, and so this is, and I think the legislature has come to respect the work that goes into this, and so we're in a good.
We got more than our money's worth.
Yeah, right.
That's right.
The council has been working on implementing case level data gathering for years. There has been growing interest in that data in several quarters, including the legislature. As part of public trust and confidence, the judiciary around the country thinks we must do a better job of telling people what we do. And so that the only thing they don't read is critiques of decisions that are controversial. OCA's been working on that. They've signed a contract with for a new system with Tyler to start collecting criminal data and to tell us about that and how they're gonna start and proceed. Give us an update.
Morning, Chief, Presiding Judge Keller, and council members. You'll have heard us talk about case level data a whole lot, and it's finally at a place where we have our foot on the gas pedal. And so we're ready to start pushing down and keep going with it. As you've heard us talk before, we've been doing a review of data elements across all case categories. And our plan right now is to begin with the implementation of criminal data first in district and county courts. After that, we will expand to civil and family, then juvenile, probate, guardianship, mental health, and then we'll move on to justice and municipal courts. So with that, we have done a very thorough review multiple times of the criminal data elements that would exist at the district and county court level. We have decided to proceed with collecting the data that is already necessary to report to us right now in aggregate counts. So we're pretty much gonna go down and like open up a branch of trees to see what all the fields are required to feed into the one count that we get right now at the county level. In addition, we have identified that there are some there is some information there that may require some type of policy change. And so what you have in front of you today, the document that says review and approval of criminal data elements, is for those specific elements that may require some kind of change. We've presented this to the data committee already on a couple of occasions. And at our last discussion, we had very good conversations around the best way to proceed with these data elements that are not necessarily collected in case management systems or would require some other kind of change, not just a development with case management systems. So with that in mind, what the discussion was at the data committee was, oh, sorry, go ahead, Megan.
We're talking about how small the text
I'm like,
is.
I have my glasses on and I can't read that.
And we will email it in the Excel sheet so you can blow it up on a screen as well.
Absolutely, I have it on my
And you can
iPad.
see the full detail there. It is really tiny. But the main ones I hope are a little more legible in this first page. And so for defendant information, we've had discussion about this. If you all recall, we also had a stakeholder meeting in September of last year. And so we met with clerks, with prosecutors, defense attorneys, judges. It was a really good group and we were able to go through the very tiny text ones that you all see. And then we've continued our work from there and with their recommendations. And defendant information is one that in the committee discussion, the decision was to go ahead and proceed with capturing identifying information of defendants if there is a change to Rule 12 that would allow OCA to protect that data. So if we have it, and there's a request, we would need to release it right now, and we want to make sure we have something to fall back on to protect anything that's identifiable. So that's the first one. If not, we would hold back on collecting that until there is some type of protection before we start collecting it and have it in our system. The second one was attorney, so this information has not been captured and we believe it's gonna require some type of programming and development in multiple case management systems. But the recommendation was to go ahead and proceed with it in the first phase of data collection. We would be more than happy to work with the clerks, their vendor and our vendor, which for some of them it will be the same, Tyler Technologies. So we hope that that will be a smoother process of what fields need to be added. Orders was another one, and I'll point out that on attorney and orders, we get a lot of information requests for this, so I do think it's important to implement these in that initial phase. And it's information we just haven't captured before ever, so it will give us a lot of good insight to what is going on in the life of a case. The ones that you see colored in a like salmon shade, these we decided to put on hold, so we want to be able to tell Tyler to go ahead and start building what those connections would look like. But this is not something that OCA would require immediately, and we can revisit in the future to see where this is at. And the main thing is that, again, none of this is captured in the clerk system. So pretrial information likely lives with pretrial services or with some law enforcement agencies. Diversion information does not live in the clerk system either. And so it would give OCA time to do some more research as well and see if we can get that information from these other entities and not, burden the clerks with having to figure out how they can capture this information and feed it into their system now. So with that, given that these are brand new elements and that the first three would require some type of programming change or protection of the information that we would be collecting, we are looking to you all to review these and for your approval.
Questions?
It's a multi-year project, but we hope to be able to start connecting and receiving some criminal data spring of next year. It won't be for all counties right away. There will be an onboarding process and we'll want a couple of pilot counties so that we can do some data validation and make sure everything's good. But we're very hopeful that come early next year, we'll be able to start seeing that come in.
So you have a better model ready, like 31?
Yeah, and we'll work with our vendor to
Our vendor's
roll that
working on
out,
that
yeah.
right now. I'm sure, but is there a consideration about expunctions too, because that's.
Yes, and
I've
so.
seen a huge increase with that, I mean, it's great that we have data, but then.
Yeah, and that was actually a pretty lengthy discussion at the data committee meeting as well. We do have staff at OCA who work really hard every month just to take care of expungement orders that come in. Our bail system is a part of those procedures now as well to go and remove information. The way our system will work primarily is it'll connect to the clerk systems. So once they remove it on their end, overnight, it will be gone from our system. And what we will need to develop procedures for and processes is for those who will be doing manual entry. We still have some counties that don't have a case management system, so they'll have to enter information by typing into their keyboard. So those are the counties we would flag and do a thorough review for expungement orders.
And Judge Spillane, that the data committee had a pretty lengthy discussion about the defendant's name. And if without it, it's very you can't expunge a record without the defendant's name. And so it's essential to have that for that protection, to be able to expunge a record
And then that's the main thing
later
to
on.
expunge, really. That's
Right,
yeah,
right.
yeah, that's it. But I mean, they're gonna keep increasing, I mean.
Yes, we, with the e-filing system in Research Texas and now the bail system, it's very familiar with that process.
But that's what we also talked about a lot is some of this stuff that's PII, like, let's not collect it unless we have a reason to collect it, right? But some of the stuff, like birth date helps you determine the age of the defendant, which might be an important thing that you would want reports on, right? So, okay, let's collect birth date, you know, or whatever it is. So we talked about that.
Other comments? I think we need a motion to adopt the elements that they've identified to use in implementing. A second?
Second.
Any other discussion? In favor, aye.
Aye.
Opposed? It carries. Thank you, Alejandra. Thank you very much. Now we have a new Center of Excellence that we're especially excited about. It's gonna do the introduction.
We're really cooking on this agenda, guys. Like, I was expecting to have to go at like noon. So today, we are putting forth our very own Judge Valencia Nash and some members of her staff sitting behind her, as well as the full members of her staff, which are downstairs. Judge Nash is our 9th court to be put forward for recognition. She's going to be our 5th Justice of the Peace, and she's gonna be our 2nd Urban Justice of the Peace. Judge Nash presides over Precinct 1, along with one other judge, and you are the largest precinct in Dallas County, aren't you? So she stretches all the way from downtown Dallas, down into Lancaster, and over into DeSoto. So she has a fairly high volume docket, which sometimes gets eaten up just simply because she's the last court in the building. So sometimes her court visitors just turn right at JP 1-1, and then she never sees them. But with e-filing, that number is going to go up for sure. What strikes me about Judge Nash is that there is no part of her court or process in her court that does not build on another. Her court operations are foundationally strong and incredibly good. So basically, whether it's case flow management, staff management, customer service at the window, everything is built to feed into everything else so that she can effectively manage her court. We sat and watched her do, I think you did small claims, you had an animal abuse case and an eviction court case. She knew exactly how many cases she could move in the time frame. She knew exactly how many people were scheduled on her docket, and she didn't run a minute over. Moreover, she seamlessly can transition from live hearings in front of her to hybrid hearings. She had several court attendees that were only remote Zoom, and they never had to leave the issue. We had no technological issue. She showed evidence. Everything worked incredibly smoothly. One thing to note about Judge Nash and all Dallas County JPs is they've only just recently gotten a case management system as of October 2022. So we've been discussing her business analyst, who has been incredibly helpful to her and the other JPs in Dallas County. But that presents a significant challenge to a high volume court where some of her case files are currently paper, some of her case files are currently digital, and some of her case files are both at the same time. So to conduct this out, she has to have a pretty solid court operational plan, and that's evident in both the things that she adopts from the Justice Court Training Center as well as her own desk books and standard operating procedures to make sure that she can move a case from start to finish as efficiently and as effectively as possible. Beyond that, Judge Nash, like all of our JPs that we've had so far and all of our centers of excellence, is a dedicated public servant and member of her community, in fact, his hometown. She represents the district that she grew up in. One of the things that stood out with her is that in her lobby, she allows the Mint Foundation, which provides eviction assistance and resources to indigent defense who may not have the ability to pay, as well as the Dallas Eviction Assistance Program, which provides legal representation to pro se litigants facing eviction charges in her court. And she allows them to stay there despite the fact that they can be challenging. Let's just call it challenging. I could go on about Judge Nash, but I wanted to go ahead and make sure that we gave everyone the time that we have saved on this. And I have nothing else to say other than it's been an honor to work with her for the last 6 or 7 months.
Congratulations.
You wanna introduce your?
Yes, today, my whole staff did come. They're down in the law library, but this is my chief clerk, Regina. This is my collections clerk, Diane, and my accounting specialist, Anitra. And so they've worked with me quite a bit, and Michael says 6 months, but it's more like 2 years. We've been kind of ongoing and exchanging information. It's really a process, as Judge Maderi said. It really is heartwarming. You know, I told Judge Sawyer that I've been on this council. I think the longest other member is Judge Keller. I've been here for 16 years, and it's just seeing so many centers of excellence. It's just like I couldn't just sit here and not participate, because I do believe that we should have great courts and we should serve, and it matters to me. So again, I appreciate the program, Senator, more than you know. We certainly have a long way to go, but this was a good challenge for us to really identify some weaknesses and some strengths and, you know, continue to try to improve. So thank y'all for having this program, and Michael's been phenomenal. I promise I didn't pay him a dime to say all those nice things. But no, it's been wonderful and I appreciate it. And he did tell me that I'm not official until y'all vote on it, so I better sit here and hope that it's a yes.
Well, you bring credit to the program. Judge Nash, and we're proud of you.
Does this mean we would have 3 members of the Judicial Council who are centers of excellence?
Yes, and Judge Laird.
We can give partial credit to Judge Miskell. I ran across her court profile the other day. She was in the middle of it when she got appointed, so.
Fiscal year next.
Do we have appellate centers of excellence? I don't think that works.
We'll work on that.
Okay.
I praise that. I think we should.
So is there a motion to recognize Judge Nash's Center of Excellence?
So moved.
Second? Any other discussion? All in favor?
Aye.
And since you got me up here and we have had the conversation about how many courts we can handle in a year, we currently have 10 programs active, wherein which they have started the program and are in various stages of working their way through it. I've got 5 district courts, 1 county court at law, 2 JPs, and 1 municipal court currently active in the program. Judge Spillane is awaiting his court review with me, and we'll have 15 more, including Judge Spillane. Beyond that, including for Judge Laird, we have Judge Hudson in Montgomery County Court at Law number 4, and we also have Judge Susan Barclay at the 117th out of Nueces County. So we'll be having quite a few moving along.
Is Stith on there too? From
He's there. I just haven't heard from him. I heard from Judge Barclay.
This is such a wonderful program.
Yes, it is.
We all feel ownership, but I think it's mine. I don't know.
I think it's yours.
I have no reason to feel that way. I just feel.
With that, I'll take my seat.
Thank you, Michael.
I may have told you, I had a speech a couple of years ago, 3 or 4 years ago, to the bar in Edinburgh, Scotland. And when I got done, I was having a reception, and one of the lawyers came up to me and said, "Do you know Judge Villarreal in Laredo?" And I said, Well, yes, I do. What, how do you know him? He said, well, I've watched his, moot court, on, the internet, and we're doing one over here that's just like his, and, so you've been up to, improving the judiciary several ways, Senator.
Trying to.
Yeah. Okay, is there any new business or other business for the good of the order? Next meeting is December 13th. And we'll take some pictures if Judge Nash wants to in the courtroom. And with that, I believe we're adjourned. Thank you very much.
Like now or upstairs?
No, we do upstairs, so we can.
Yeah, I'll bet.
I don't see him much.
No, that's all right. No.
Yeah,
I saw a look go by and I was like,
Oh, no, I was just coming to see you and get some pictures.